This podcast is sponsored by Murgitroyd, intellectual property attorneys. For more information on today's guest and our company, visit murgitroyd.com/podcasts.
Hello and welcome to the 6th season of Murgitroyd's Innovation Talks podcasts. We're delighted you have joined us. If you have any questions, you can email us at innovation.talks@murgitroyd.com or contact us via Twitter @Murgitroyd. And please remember to subscribe so you don't miss any future episodes. So let's go straight into today's podcast.
Hello, my name is Terry Devlin. I'm a patent attorney in Murgitroyd, and I'm delighted to be joined today with my colleague, Chris Cairns. Hello, Chris.
Hi, Terry.
Hi, Chris. Chris is a director and trademark attorney in Murgitroyd, and we will be discussing the possibility to obtain fast registration of intellectual property. And we'll start by asking Chris, how fast can one obtain a registered trademark?
It's important to note that trademarks are not like domain names. They're not instantaneous. Rather, trademarks have to go through an examination process. In the UK, that examination process, it can typically take up to 6 months to get a trademark registered. In the European Union, that's typically 6 months, 12 months to get a trademark registered.
It sounds like a relatively speedy process, but can it be accelerated to be even faster?
I suppose the answer is, in some ways, yes, it could. And in the UK, it was possible to request fast-track examination upon payment of a fee. But the UK IPO is very, very efficient, and they're now examining applications very, very quickly, certainly within 1 month. So because of that, the fast-track examination process is currently unavailable because it is not required.
I was thinking about acceleration and any advantages of it. Do you have any thoughts on that?
Yes, there are advantages to getting a quick registration. The most important one is that one can only enforce their trademark once it is registered. So it is advantageous to obtain a registration very, very quickly.
Are there any steps that one could take to speed up the registration process then?
Given that it is very, very quick just now, I mean, there are certain things that you can do to make it easy for an examiner to examine your application. For example, make sure that your trademark is distinctive. What I mean by that is that it's not descriptive and it's not generic. If you think of Kodak or Google, these are very, very distinctive trademarks. Whereas if you're thinking about something like quick dry for paint, then that's arguably going to be descriptive. And for an examiner, when it comes to the types of trademarks which are Kodak, Google, they're going to be very easy, very quick to examine those. Whereas if it's something like quick dry for paint, then an examiner is more likely to issue objections, and that's going to delay the examination process. And it may end up that your application is refused. The other step is that when you're filing your trademark application, you need to provide a list of goods and services. If you're able to pick acceptable terms, so terms that the Intellectual Property Office already recognise, then it's effectively going to rubber stamp your trademark application, and it's going to make it a lot easier for the examiner to do the examination very, very quickly.
In trademark registration, I certainly know from patent point of view, some fields of technology are very, very busy. You know, the basic mechanical stuff, examiners are flat out and have got major backlogs. Would the classifications of a trademark registration, would certain ones of those be notoriously slower in terms of registration, or is it just as quick regardless of what goods you're registering the trademark for?
Yes, I think it doesn't really depend on the technology or the goods that you're filing for. I mean, what may slow down the examination procedure is that what people are doing when they're filing the trademark application, they're ticking the boxes to effectively designate lots of goods within a particular trademark class. So what's ending up is that people are filing trademark applications and the list of goods and services is so long that it would take an examiner quite a long period of time to make sure that those comply with the regulations. So
Right, okay.
that's the only thing that we do see, is that because people are now designating very, very long lists of goods and services, that it can sometimes be difficult for examiners to examine them quickly.
Yeah. No, that's interesting. I mean, some of the things I have are still waiting examination many years on, trailers and agricultural kind of stuff.
So Terry, in terms of patents, how fast can one obtain a granted patent?
Well, it's a very interesting question, especially after your great answers on the speed of trademark registration, because the patent process is a lot longer. Even when speeded up, it's still a lot longer than the trademark registration process. Essentially, in the UK, the goal is that a patent is granted within 4.5 years from when an application is initially filed. However, in some technological areas, it can be longer than 4.5 years. It could easily be 5 or 6. So there's a very long, drawn-out process, certainly potentially is a long, drawn-out process, with a multitude of different steps that need to be taken to get through to grant.
It seems like a very long time. Is it possible to accelerate that process?
It can be done, yes. There are a number of ways in which you can do this. The patent application is filed. You have to ultimately request a search and request an examination and have the application published, all before the patent grants. And you have a lot of time to request the search, for example. That can be requested 12 months from filing, and then it might be published 6 months after that, and then examination requested 6 months from that. But you can combine a lot of these steps in one. And an initial, probably the most common method of speeding it up would be a combined search and examination, which you can obtain upon request from the Intellectual Property Office. You simply ask for it to happen, you pay the relevant fees, and typically you would get your search and examination report within 4 months rather than a usual 3 years. You can alternatively request acceleration just of the search, and once you have that, then ask for acceleration of the examination. So you're basically splitting them back into 2 steps, each one accelerated as you so wish. And similarly to the trademark situation, when you mentioned about registration, you can't obviously enforce a patent till it's registered. But when a patent is published, you can backdate your patent rights to publication if someone is infringing it at that point. So you can request accelerated publication also.
And so when typically does publication occur?
Typically, publication would occur 18 months from when you file your patent application, and provided you complete all the interim steps and requirements. But with accelerated publication, you can request that and your application would go into the public domain, generally speaking, within the next publication cycle, which could be 4 to 6 weeks, realistically.
And is there anything that the applicant can do or the patent attorney can do to sort of speed up that process in terms of the drafting of the patent application?
Well, generally speaking, it would take 2 to 3 weeks to draft and file a patent application. Things can be done quicker if there was a major urgency. For example, if the applicant was going to disclose the invention and therefore the application must be filed beforehand, in which case all stops would be pulled out and we can draft and file patent applications in as little as a day. It's not ideal, but it's possible. So where you have time to consider your application, it's better to use that time to produce the best possible patent specification before you go and file it. So yes, from that point of view, things can be sped up, especially in less than optimal situations.
So if a client was looking to get a granted UK patent as quickly as possible, what is the shortest possible time that could take?
In my experience, the shortest possible time would be 12 or 13 months is possible. And that is by using combined search and examination, early publication, and responding to examination reports very quickly. And currently, or certainly nowadays, we would be doing this on applications very commonly that have green technology in them, or any technology that's of environmental benefit, because the Patent Office have another program called the Green Channel. And any invention which falls within the category of having environmental benefit can be accelerated by simply writing to demonstrate why the invention relates to such technology. You would get the search very quickly. And if you request accelerated examination, you would get the examination report very quickly. And provided you reply to the examination report and answer all the objections, 12 months is possible. the application must be published, and a period of 3 months elapses in which third parties can submit observations on it. But once that period passes, then there is no barrier to the patent being granted early.
Okay, that makes sense. Would there be any advantages to drawing out the patent process, so perhaps waiting the 4 or 5 years?
There are circumstances where, yes, it's perfectly acceptable to let the process, run its normal course. The advantage is you're spreading out the cost of each individual step, as well as that it gives you time to consider the commercial potential of the invention, to establish your marketing practices, and to determine where you might want to be protecting this invention outside of the UK, because you can still do that within 12 months of filing your application. And of course, once a patent application is published, then your competitors can see what exactly it is you're trying to protect. And oftentimes it's worth delaying that for the 18 months, the common time period, so that it still remains secret in the meantime if you're still developing the idea. We do always encourage applicants to request a search when they file their application. And even when you don't request acceleration, you generally get a search report within 6 months. And it's good to do that so you get an early indication of whether or not your invention is indeed patentable. But it's good to have that in hand so you're not committing to more expensive applications in other countries if it turns out actually that the invention isn't novel and inventive.
Is there anything else that we've missed on the patent side?
Yeah, well, there are a couple of other methods of accelerating your patent prosecution in the UK. For example, if your UK application has derived from an international application, and so therefore it's going into the UK as a national phase application, it can be put into a fast track if the examination or the international preliminary report on patentability is fully positive. And if that is the case, the UK Patent Office will essentially allow your patent in the UK to go to grant on the basis of the positive opinion of the international examiner. One thing to remember during acceleration, if you've requested acceleration by any of the methods, if you request an extension of time to respond to any examination report, that immediately renders your application non-accelerated and it reverts just to normal pace. So it is important that the applicant understands that the onus is on them to be expeditious in dealing with objections which are raised when you have requested acceleration. And in terms of other countries, at the European Patent Office, they have a procedure called PACE, that's PACE, and they will allow an application to be accelerated when it is practically feasible from the EPO's point of view. You don't have to provide any reasons. You can request it in relation to search, and you can request it in relation to examination. And generally speaking, if you request accelerated search, you would get that within 6 months. And if you request accelerated examination, you should expect to get an examination report within 3 months. In each case, you would have to pay the fee for search and the fee for examination. So you would have to stump up for that earlier than normal. And of course, in the EPO, you can also request early publication in similar manner to the UK Patent Office, but they won't publish it as quickly as the UK Patent Office. It could still take potentially up to 5 months for the publication to happen. So it possibly wouldn't save too much time.
Thanks for that, Terry. It does seem very, very complicated, and certainly needs someone like yourself looking after that process.
Well, yes, absolutely. The process does give us a bit of breathing space and helps us handle quite a lot of things at one time, but it's not as fast paced as your own area of expertise. But thinking to other types of IP, design registration is another way to protect innovations, or certainly the appearance of products. Can that registration process be sped up in any way?
Well, again, designs, like trademarks, are not like domain names. They're not instantaneous. They have to go through an examination process, but luckily not like the patent process. For designs, it's mainly making sure that it complies with formalities. When you file a design, it must be new at the date filing the application. But interestingly, the Intellectual Property Office does not actually examine whether the design is new at the date of your application. But ultimately, if you're seeking to enforce your design registration against a third party, then that question will more or less be raised in proceedings. With designs, it's not possible to accelerate the procedure, but typically it takes less than 1 month to get a design registration, given that it does not go through this very, very lengthy examination process, for example, like patents. So with a design registration, You can get that within a few weeks, certainly within 1 month. And if you're looking at Brexit just now, then there is still time that if you file an EU design application, that it will be registered within 1 month. And so therefore the owner will get a UK cloned design registration automatically and at no additional cost. With designs, it's not so much about speeding that up because the process is very, very short. But there are some cases where you might want to delay that process. And this is a thing called deferred publication. And it's a little bit strange to think, well, why would you want to defer publication? Surely you want your design to be registered very, very quickly so that you can then enforce that registration against third parties. But if you think about the fashion brands, then they're looking at a new type of design. Then what they want to do is that they want to get their design registration on file. But as soon as it's on file, they don't want to tell the world about that within a few weeks or certainly within a month, because it's going to take them 6 months, 12 months to get the product to market. So typically what they will do is that they will file their design application, they will request deferred publication, so that then gives them the lead time to get the product launched to the market. Once that's done, then they will request that the design application is published and subsequently is registered very, very quickly. So that's actually a case where the fashion brands may actually want to defer publication so that they sort of can get everything in order, so that they've got the protection on file, and then they can do the groundwork in getting the product to market, and they're still protected because they filed their design some 12 months or 2 years ago.
That's very interesting, Chris. In fact, I think I've experienced that with some of the car manufacturers who release their car designs. It appeared to me that they were registering designs about 1.5 years or so before vehicles were actually getting launched at motor shows, and the design registrations had all been deferred in the meantime. So they're revealed with great fanfare on the day of a show or something like that. I hadn't considered it in many other industries.
It works in fashion, which is, you can imagine jewellery or anything else. I mean, if you look at iPhones, then even Apple's, they might want a quick registration or a quick design registration. Then it's obviously a balance about getting the timings right about the product launching to the market and getting the protection in place.
Well, Chris, thank you very much for sharing your expertise and experience with me. It's been extremely informative, so I appreciate that. Thank you.
Yeah, likewise, Terry. Thanks very much for explaining the patent process and how to speed that up, and all the best.
Thank you very much. Bye now.
Bye.
Thanks for your time today. We hope you found today's podcast valuable. And remember to subscribe so you don't miss any of our future episodes. So until the next time, goodbye.
Our business is founded on trust and collaboration. The subjects we choose for our podcasts are topical and informative. We are always looking for suggestions for new topics for discussion, so if there's an area of IP that you're keen to understand better, please drop us a line at innovation.talks@murgitroyd.com.